All right, I'm going to call to order the December 15, 2022 meeting of the Sentencing Guidelines Commission. The first item, the first thing we need to do is roll call, so I'll ask Nate to go ahead and read the roll.
I was already in position for the next thing, so. All right, the chair has called the roll. Roll call, Estrada. Estrada present. Hansi. Hansi absent. Ibrahim. Ibrahim absent. Knudsen?
Here.
Knudsen present. Ladd?
Present.
Ladd present. Larkin?
Present.
Larkin present. Middlebrook?
Present.
Middlebrook present. Moore?
Present.
Moore present. Morath?
Present.
Morath present. Schnell?
Here.
Schnell present. Chair Mitchell?
Present.
Chair Mitchell present. Madam Chair, there are 9 members present, 2 members absent.
And with that, we do have a quorum today. Next item is approval of the draft meeting agenda. I'd entertain a motion to approve the agenda.
So moved.
Commissioner Knudsen moves and Commissioner Schnell seconds. Any discussion on the agenda? Hearing none, please go ahead and call that vote.
To the Knudsen motion to approve the agenda, Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim? Ibrahim absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the agenda is approved unanimously. The motion is approved unanimously. Next is approval of draft meeting minutes from November 3rd, 2022. Those were provided to the commission a week in advance. I would entertain a motion to approve the minutes. Commissioner Middlebrook makes that motion. Do we have a second? Commissioner Estrada seconds. Any discussion on the minutes? Hearing none, let's go ahead and vote.
To the Middlebrook motion to approve the November 3rd meeting minutes, Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim? Ibrahim absent. Knudsen?
Here or present or approve, yes. Yes, I approve.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore? Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. I'll give Commissioner Knudsen a little slack because he's been in meetings all day. And he's going to stay with us. Okay, so the next item on the agenda is a statistical summary of the 2021 sentencing practices. I'll turn it over to staff for that. Commissioner Director Wright.
Thanks, Madam Chair. And Jill, if you could just start by sharing the presentation. It should be all set up just to share. While Jill's doing that, this is basically serving 2 functions. One is we're preparing you for the next agenda item, which is the report to the legislature. And part of that report includes this summary of 2021 sentencing practices. 2021 being the most recent year for which we have data. It does take us a while, and we can talk about that at a different time, but it does take us a while to assemble our sentencing practices data, and we do we just have that done now, and we've begun the analysis. We didn't even have the analysis done by November. The second thing it does is it gives you an idea of what's going on in the world of sentencing, which is important for you to know that as the Sentencing Guidelines Commission, to know how things are happening. Of course, it's very important to keep in mind that 2021 data, like 2020 data, is tainted by the pandemic and by the criminal justice system's response to the pandemic. And so these may not be typical years, but you will find that we do interject some notable statistics, notwithstanding the fact that these are unusual years. So Jill,
Thanks, Nate. Is it shared content?
share content, yep.
Okay.
And then it's that PowerPoint one, yep. And you got to click share.
Okay. Thank you. Thanks, Nate. Thanks, Madam Chair. Minnesota courts sentenced 14,429 felony cases in 2021, which is up from 11,517 cases in 2020 and down from 17,335 cases in 2019. The all-time volume high was in 2017 when 18,288 cases were sentenced, which is nearly identical to the volume in 2018. Volume was up for all offense categories in 2021. As a proportion of all cases sentenced, person offenses accounted for 30.8%, property accounted for 26.2%, drugs accounted for 27.1%, and all other offense categories accounted for 2 to 5% of cases sentenced. Case volume was up by 25% in 2021. This was the largest single-year increase in MSGC history and follows 2020's largest single-year decline of 34%. It's assumed the drop in 2020 was due, in large part, to the effects of COVID. The courts reported on initiatives to clear the major criminal case backlog by 20% every 4 months until the backlog is eliminated, which they estimate will be June of '23. Before 2020, there was a 5% drop from 2018 to 2019. And before that, you can see a 7-year run of annual percent increases from 2010 to 2017. Slide 4 shows the percent change we saw in the last slide by offense type. The darker the shading, the higher the level of change. Greens are decreases and blues are increases. In 2021, all 7 offense categories increased. The increases ranged from 20.3% for person offenses to 33.3% for weapon offenses. The weapon category includes possession of a firearm by a felon convicted of a crime of violence, discharge of a firearm, and other weapon-related offenses. This slide shows the race and ethnicity of people sentenced from 1981 through 2021. The white percentage decreased by 25 points between 1981, when it was 81.8%, and 2009, when it was 56.5%. This was largely due to the increase in the Black percentage, although the percentages of other races or ethnicities also increased. Of those sentenced in 2021, 56.9% were white, 25.5% were Black, 9.3% were American Indian, 5.5% were Hispanic, and 2.7% were Asian. This is similar to the distribution in recent years. Slide 6 displays the distribution of race and ethnicity by Minnesota's 10 judicial districts. The districts with the largest Black percentages were the 2nd District, which is Ramsey County, and the 4th District, which is Hennepin County. Those who are Black accounted for over half of the people sentenced in the 4th District at 54.8%, and almost half the people sentenced in the 2nd District at 49.2%. Those who are American Indian comprise a larger share of people sentenced in the 6th District, which includes St. Louis County, and the 7th and 9th Districts in northwestern Minnesota. The districts with the largest share of those who are Hispanic are in the 3rd District in southeast Minnesota, the 5th District in southwest Minnesota, and the 8th District, which is western Minnesota. The district with the largest percentage of those who are Asian is in the 2nd District. Next, we have Nate, who is going to talk about incarceration rates.
Thanks, Jill. And before we leave this slide, I just want to point out that sort of the takeaway from this slide is the distribution of people convicted of felony offenses in Minnesota is not geographically uniform by race. So that's important because we'll see that sentencing practices are also different by geography. And sort of a corollary to those two things is that sentencing practices are not uniform by race, possibly in part because of the fact that there's not geographically uniform distribution throughout the state, and there's not uniform sentencing practices by geography. So this chart shows the total incarceration rate over time since the beginning of the guidelines era, if you will. The dark blue bar is the total rate at which people have been sentenced to some sort of incarceration, whether it's prison or local jail time, at the time of their initial sentencing event. This doesn't count probation revocations and that sort of thing, but just what happened at the time they were initially sentenced for that felony. Did they go to prison? Did they go to jail? So the dark blue line is just the sum of the light blue line and the green line, basically. The green line is the local jail rate, the conditional confinement, and then the one that is most interesting, I think, to us, since the sentencing guidelines are really govern that, is the light blue line, and then also the brown dotted line. Now the brown dashed line. The brown dashed line is the presumptive prison rate. So that's the rate of cases. That's the percentage of cases for each year that the sentencing guidelines said this is a prison case. This person should go to prison, either based on guidelines policy or by statutory policy as incorporated in the guidelines. And then the blue line is the rate of people who actually went to prison. So the space is what I'm really interested in. The space between, let's see, the space between the light blue line and the brown dashed line is what I find to be interesting. And you see that the brown line has been going up, not consistently, not every year, but has been going up over time, and is currently at a record rate. We'll talk about that on the next slide. The blue line has not been going up as consistently. It's kind of remained in the I would say low 20s, mid 20s for the most part over time. There were some points in the mid-teens where it did get into the high 20s, but for the most part it's been a fairly consistent number. But the guidelines presumptive prison rate has gone up over time, so that right now we find ourselves with a record gap between those two. 14.6% percentage points is the difference between the guidelines presumptive prison rate and the actual imprisonment rate, which was very low, relatively speaking, in the early years of the sentencing guidelines, and it's gotten considerably higher. The next slide shows some of these record rates that we've seen this year. So we've already talked about one of them, and that's this dashed brown line. That's the presumptive prison rate, which was 36.1%. Never been that high in the history of the sentencing guidelines. Then this other rate is the mitigated dispositional departure rate when prison is recommended. So what are we talking about there? So we're talking about those cases that are represented by the brown dashed line, right? The presumptive prison cases. How many of those cases actually went to prison, and how many got a mitigated dispositional departure? So the mitigated dispositional departure means that they didn't go to prison even though the sentencing guidelines recommended it. And that is a record high number, 45.7%. Now, as I said at the outset, these are unusual times. This is COVID. This is 2020 and 2021 are unusual years, and both of those are, 2020 was the record before 2021 came along. So these perhaps we should take these numbers with a grain of salt. But there are two reasons why I am interested in keeping an eye on these numbers. One is basically the sort of continuing viability of the sentencing guidelines. I guess at what point do the guidelines cease to become guidelines if the number of if the rate at which people are not getting the presumptive prison sentence when the guidelines recommend prison is starting to approach 50%. That's I think some commissioners might be concerned about that. The other reason why I think it's of concern, and this, I will say my memory isn't as good as what I'm about to say. I went through Dr. Chris Eugen and Hannah Schwendemann's presentation in preparation for drafting the report to the legislature language. They gave us, I think it was in June, their research results, and they basically controlling for all factors, controlling for geography and controlling for criminal history score and controlling for all these factors. They looked at, where are there inequities creeping into the system, and really their primary finding of a difference between the sentences that white folks were getting versus non-white folks was in the area of mitigated dispositional departures. That controlling for all factors, their findings were that a person who was white was more likely to get a mitigated dispositional departure than a person who was non-white. So couple that with the fact that the mitigated dispositional departure rate in cases where presumptive prison is recommended has reached a record high in 2021. Couple that with the concern about the differential between white folks and non-white folks in terms of how much they're getting these when you control for all other factors. That's a second reason for concern. Again, going back to, this is 2021. 2021 was a weird year, as was 2020. And frankly, I don't know if 2022 is going to be any more normal. I'm not sure whether it's going to be 2023 or 2024 by the time we start getting to what we can consider to be normal data again. But it's at least something that some commissioners may want to keep an eye on. So these are incarceration rates
Hey,
by, yes, Madam
Before
Chair.
you go on, I don't know if you talked about the age of the case
Oh,
there.
I didn't.
I think that's important.
Thank you for pointing that out. This is another data point that I think is also a record, although this chart only goes back to 1991, so I couldn't swear to that. But I think it's also a record. We looked at the age of the case, and this I think goes to, maybe not, but I think it also goes to 2020 and 2021 being odd years. Odd, not mathematically odd, but odd as in unusual years, because so this is sort of a crude measure of how old these cases were at the time they got sentenced. So we're taking the sentencing date and subtracting the offense date and coming up with a number in months and figuring out what is that median case age at the time it's sentenced. It really had been 8 months for quite a while for the most part, sometimes 7 months, and back in the early 90s it was 6 months, or back in the 90s I guess it was 6 months, but then it started climbing up in 2019 to 9 months, and then 10 months in 2020, and then 12 months in 2021. So that may have to do with case backlog. There may also be an overlay of, these may not be typical cases. These may be more serious cases than normal. So again, these are unusual times. I don't think we need to necessarily, make drastic changes based on some of these anomalous data points, but they may not be anomalies. They may be trends, and we may need to keep an eye on them in the future. So that's my point there. All right, so incarceration rates by gender, which is the first two bars, and then by race and ethnicity, which are the rest of the bars, and then we have the total rate there at the bottom. So these bars do not go up to 100% because basically if there's white space at the top, those are the cases that neither got jail nor prison at the time they were sentenced. But there are differences in what percent got sentenced to prison, and again, that's the one I'm mostly interested, that dark blue at the bottom. It varies by gender, it varies by race, and as we'll see on the next slide, it also varies by geography. But it's important to note the little brown mark there in the middle of the slide, and that may not be brown, it may be dark red, I don't know, but I'm going to call it brown. That the little brown mark in the middle of the slide, the bar, that shows the presumptive rate. So, and the presumptive rate is determined by the sentencing guidelines, which are determined primarily by the criminal history of the person who's being sentenced and the severity of the offense that they're being sentenced for. So, there is variation by race, but there's also variation by presumptive prison too, by race. And you see the same thing with geography. You can see that there's quite a bit of range there in terms of both the imprisonment rate by judicial district, and we do have a map of the judicial districts in your slides. The second, I'll just point out the two judicial districts that are one county each. The second is Ramsey County, and the fourth is Hennepin County. The fourth is the largest single judicial district in the state. Again, variation by the total prison rate and also variation by the presumptive prison rate. The average pronounced sentence length has also gone up. And that's another record, 54 months. We haven't seen 54-month average sentence length in the history of the sentencing guidelines. Again, this may all be connected. These may be more serious cases, and that may be why we're seeing higher presumptive prison rates and why we're seeing longer prison sentences. I'm not sure if that would explain why there's a higher mitigated dispositional departure rate. But we're also seeing lower pronounced local confinement durations. So we're below 3 months for that for the average local confinement time, and judges can sentence defendants up to 365 days if they're not sending the defendant to prison. Let's see, I think Katie was going to take over the departure rates. Is that right? But was I going to talk about probation cap departures? Let's see. I think I was, and I don't have my notes with me. Yeah, I did not print this off. Let me see if I can pull it up here. So the chair asked us to take a closer look at probation cap departures. So just a little background on that. So in 2020, effective January 1st of 2020, this commission created a presumptive cap on probation for most offenses, excluding crim sex offenses, excluding homicide offenses. But for most other offenses, if a defendant's being sentenced to a probation sentence, there's a 5-year presumptive probation cap. So in order to impose a probation duration of longer than 5 years, the judge has to be able to articulate substantial and compelling reasons for doing so. So this is 2021 data. Since this went into effect for crimes that were committed on or after August 1st of 2020, not all cases sentenced in 2021 were committed on or after August 1st of 2020. So about 44% of the cases that were sentenced in 2021 would have been under this regime, this 5-year probation cap. So we're still looking at pretty early data here. And if you look at the different departure rates, you'll see no departure in about 70% of the time, which you may be scratching your head there and saying, wait, I thought he said a few minutes ago that we had a really high mitigated dispositional departure rate, but this is only showing that 27% of the cases had a mitigated dispositional departure. That's because this is talking about all cases, and that other rate in the high 40s, that was talking about only those cases that were presumptive commits to the Commissioner of Corrections, and specifically mitigated dispositional departures. This is talking about any kind of mitigated departure, whether durational or dispositional. Very small numbers on the aggravated departures, and about 1% on the mixed departures. This is one chart that's going to change. We're going to present a slightly different chart based on some of the comments that the chair.
No, it's starting.
Based on some of the comments that the chair had, we're going to be amplifying that probation cap and the mixed departure rate a little bit. But I can tell you that right now the offense category with the highest probation cap departure rate was felony DWI at 35%. So the statutory maximum there is 7 years, which is 2 years longer than the presumptive 5-year probation cap. For the average length of stay for cases with a 5-year probation cap, the average length of stay was 8.6 years for those cases that, I think that's among those cases that had the departure. Interestingly, there was also a departure rate among cases with a 4-year probation cap, which is kind of funny because that's not a departure from the sentencing guidelines. That's actually an illegal sentence. If say you have fleeing a peace officer in a motor vehicle, the statutory maximum is 3 years and a day. A lot of times you'll see people get 5-year probation for that. Statutorily, 4 years is the maximum you can get for that, for probation. So we're kind of policing that now. Honestly, your staff is policing that now and letting them know, oh, this is a departure from the sentencing guidelines. It's also an illegal sentence. So a lot of those are getting corrected. And that's something I should point out about these. Not included in the data here are cases where people were departing from the guidelines or from the statute, didn't know they were departing from the guidelines or the statute until your staff talked to them about that, and then the judges would change the sentences. So then they weren't departures anymore, and they don't show up in the data. But that is a case where your policies were having a direct impact. All right, so Katie, I'm going to turn it back over to you now. And
Madam Chair, can I ask a couple of questions before we switch speakers?
Sure. Commissioner Ladd, what's your question?
Thank you. On page 8, when you were talking about the age of the case, did you say that the age of the case was based from the date of the offense to the date of disposition, or versus the file date versus the date of disposition?
We took the offense date to sentencing date.
Okay, and I would just as a comment, I think to that would be concerning in terms of trying to understand maybe why these numbers are the way they are. Typically, when you're waiting on information from the BCA, or a lot of times with your crim sex cases, they're late disclosures and that sort of thing. And so the dates of offenses occur a lot further ago than when they're actually filed. And then that coupled with waiting for the delays that are with the BCA, with the backlog that occurred as a result of COVID, I think that probably contributes some. So the date of offense versus the file date of the complaint, I think, to me is an interesting sort of distinction. And then on page 11, when you were talking about the local sentence or the local incarceration, and where you've got the local sentence of 87 days, is that the date that was 87 days pronounced as sentence, or that was the total amount of time that they served on whatever sentence was imposed? So they served a maximum of 87 days on the life of a sentence before they were discharged.
That's all as pronounced at the time of the sentence. So this is looking at basically the sentencing order.
Sure.
And what does the sentencing order say? Can I ask you a question, Commissioner Ladd?
Sure.
So do you think, are you saying it would be more useful to present, because I mean, I just thought it would be helpful to look at from the date of offense to the date of sentencing, I don't know, kind of in the view that, a defendant might look different, I guess, and this is kind of from my experience. If it's a really old case and the defendant's kept his nose clean for, 2 years or 3 years at the time of sentencing versus, it's a fresh case and we don't know that yet, that might impact the sentencing. But are you saying it would be more interesting to look at the age of the case in terms of the date of filing to the date of sentencing?
Well, there's two categories that I see a lot where there's a long delay between the date of offense and when it's actually filed, and then you get in the court process before you get to disposition. And so I would say a lot of the criminal sexual assault offenses, and that has to do with when they're reported, and then if you're waiting for forensic information from the BCA, that takes a long time to get the evidence back in order to make a determination whether or not you can even charge. Similarly, with the drug investigations, if there are a drug task force involved and they're with the ability to be able to use a 90-day time period in multiple counties to sort of, do control buys, that sort of thing, right out of the gate before you even file those, you're already 3 months or 4 months past when the activity of the offense was even occurring. And so I just feel like that might skew it a little bit because sometimes you can't file a case because you don't have your evidence for a variety of reasons. And so when a case languishes on for 12 months, I don't think that it's indicative from the date of offense to disposition, because the dates of offenses sometimes are different than when they're actually filed. So I just point that out because I do think that there's a distinction in those types of things. And typically in the drug crimes and the criminal sexual conduct offenses, you do see some delays between the dates of offenses and when they're actually filed.
Mm-hmm. Okay, thank you.
Thank you.
And just, it is helpful for us if you have any comments on how we're presenting the data, any ways we can improve it or make it clearer. This is definitely a two-way communication street here. So if you see anything like that doesn't make any sense the way you're showing me that, please let us know. This is, as we said, this is part of the report to the legislature. So to the extent that you can improve your report by giving us feedback at this time, that would be very appreciated. All right, Katie,
Commissioner Schnell?
you're on slide 12, I think.
Hang on one sec here. Commissioner Schnell has a question.
Oh, Schnell.
So I'm going to go back a little
Yeah.
bit here if I can, as long as we're just asking some questions. When you do the distribution of felony cases by race and judicial district, just from a contextual standpoint, is there any way, or would there be a problem with this of showing from official state data the percentage of population by that and maybe it's not as clean by judicial district, but it would tend to kind of show kind of what disparity may look like relative to percentage of population in the judicial district.
Sure. So you're saying on slide 6, where we've got the distribution of felony cases by race and judicial district?
Yeah, I just wondered if that would be just because I think it does illustrate it more clearly, kind of, and when you look at it contextually from the standpoint of percentage of population in that district by race or group.
Yeah, we do very much track the census data. So we would have the adult population in each one of these districts, and every one of these categories, we would have the adult population that would correspond to that. So we could.
I just think it would be
side by
really
side.
good context to have as part of this data.
Okay.
Commissioner Knudsen?
Well, it's, we've seen some of that data before internally and whatnot. And it's interesting, but I'm not sure what it tells us, because you might have a certain percentage of population, but that's not the population that's committing the offenses in this jurisdiction. So we'd have to figure out, well, what's the residential address or the county of residence for those that are committing the offense in Minneapolis or in Hastings or that kind of thing. So it's hard to grab onto something that might be meaningful.
Yeah.
Commissioner Schnell?
And I agree. I think the challenge becomes when the gap becomes larger, really significant, then, it would be hard to account for all of that cross-jurisdictionally, I would guess. And so that's where I think that context does provide some benefit. I would agree with you 100%, though. Cross-jurisdictional issues are going to certainly account for some of that, but in some areas, it's going to be, some of these judicial districts, it's going to be even tougher. I think when you look at the gap between percentage of population and the percentage of cases, felony cases by race in that district.
Commissioner Estrada?
And I would agree, and I think, if I remember correctly, Commissioner Warnick back in the day had asked for similar stats in a report that gave the population, because it really does show that disparity. And, in my role, I speak about racial disparity quite a bit, and having to point out, like, Indigenous people make up 1.1% of the entire Minnesota state population, and yet we're seeing, them represented in our systems by exponentially higher. So I think that comparison does help in giving people a better understanding of what we're talking about. I also wanted to highlight Commissioner Ladd's point. Initially, Nate, when you talked about, offense date versus charge, my mind kind of went with Commissioner Ladd and like, oh yeah, this might tell us how long it's taking to get cases resolved. And then when you talked about like, well, no, from your mindset, you were looking more at the client may look differently from the offense date. I think both are important, right? Because if we're talking about backlog and how quickly we're getting cases resolved and stuff, I think both of those statistics are very important. And I think there's value in looking at it from the lens of the client and how they may appear differently from offense date, and then also looking from the lens of being able to say, our numbers might be higher because of the backlog and because it's taking longer to resolve the court process.
Right.
Yeah, and as long as we're all talking, I'll just make a comment that the age of the case I found really interesting because, number one, having spent a lot of my career in the courts, I was surprised to see the number going up even before the pandemic. And because I didn't think that we were having such an increase that sort of issue should have been happening in the courts. But I am seeing that. I mean, it looks like there is a pattern there where cases are we're already taking a little bit longer to get resolved. And then, of course, the pandemic just exacerbated that trend. And so I could see how, this may relate to some of the mitigated dispositions. Somebody might come in front of the judge, and if they have been out in the community for a year already without any other incidents, then they might look like a good candidate for a mitigated dispositional departure, when maybe the judge would not have done that, or maybe all of the parties wouldn't have recommended it, would not have agreed to it, if the case had been resolved faster. So that, when I saw that, it feels like it might explain a tiny bit of that record number that we're seeing, or it might at least be one explanation for that record number. But I agree that it's a trend we're going to want to keep watching.
Right. Yeah, especially since in 2019, notwithstanding the fact that it's called COVID-19, unless you were, reading deep in the newspaper, you had not heard of COVID-19 at any point during the calendar year 2019. So
Right.
It really shouldn't have had an impact. And yet we see, mitigated dispositional departure rates going up and presumptive prison rates going up and age of case going up. Okay, so Katie, I think maybe the fourth time I'm gonna, you've probably been wearing out your mute button, but take it.
Okay, well, Nate did a pretty good job on the total departure slide, so I'm not going to spend too much time on that. I did want to add that since the spring of 2022, we have worked with the courts to inform them that when there is a departure from their probation cap, when a judge departs unknowingly, staff observes that they often amend the sentencing order to align with the presumptive probation cap or statutory maximum punishment. So just letting you know that in the future, there's definitely going to be more solid numbers with this probation cap. Now, again, the total departure rate was 30% in 2021, and that was higher than seen in 2020 at 28%. The next slide we're going to look at displays dispositional departures. And this is a departure from the recommended prison or probation disposition. In 2021, the combined mitigated and aggravated dispositional departure rate was approximately 17%. 17% mitigated, and that's when they get probation when the guidelines recommend prison, and 0.15% aggravated. That's when they get prison when the guidelines recommended probation. Effective August 1st of 2015, there was amendments to the guidelines that a sentence is executed pursuant to defendant's right to demand execution is no longer considered an aggravated dispositional departure. This change has resulted in a decrease in the aggravated dispositional departure rate from previous years. So in 2015, the overall aggravated dispositional departure rate was 4.2%, and the rate for presumptive state sentences was 6.2%. In 2021, the decrease in aggravated dispositional departure rates is apparent. On this slide, you'll see the total mitigated dispositional departure rate of 46% and rates for the offenses with the highest mitigated dispositional departure rates. The overall mitigated dispositional departure rate of 46% was the highest rate seen since the guidelines went into effect. 2020 was the second highest at 43%. The mitigated dispositional departure rate was 50% or more for second-degree assault, threats of violence, failure to register as a predatory offender, general theft, motor vehicle use with no consent, financial transaction card fraud, first-degree burglary at severity level 8, and felony DWI. Second-degree assault and failure to register have a statutory mandatory minimums, but also statutory provisions that allow for sentencing without regard to the mandatory minimum. In all offense categories, amenability to probation or treatment were the most frequently cited substantial and compelling reasons for departure recorded. In 72% of all mitigated dispositional departures, the court stated that the prosecutor agreed to the departure, recommended the departure, or did not object to the departure. In 9% of these cases, the court stated that the prosecutor objected. The court did not supply information on the prosecutor's position in 19% of these departures. Now we'll move on to durational departures. A durational departure occurs when the court orders a sentence with a duration that is other than the presumptive fixed duration or range in the appropriate cell on the grid. There are two types of durational departures, aggravated and mitigated. An aggravated durational departure occurs when the court pronounces a duration that is more than 20% higher than the fixed duration. A mitigated durational departure occurs when the court pronounces a sentence that is more than 15% lower than the fixed duration. Overall, 19% of prison cases got less time than the guidelines recommended, and 3% got more time. As with the last slide, this slide also displays offenses with the highest durational departure rates. Aggravated durational departure rates were highest for second-degree murder at severity level 10, that's unintentional murder, and first and second-degree criminal sexual conduct. At 55%, mitigated durational departure rates were the highest for first-degree aggravated robbery. Violate restraining order, general theft, motor vehicle use with no consent, and failure to register also had mitigated durational departure rates greater than 25%. In 45% of all aggravated durational departures in 2021, the court stated that the prosecutor agreed to the departure, recommended the departure, or did not object to the departure. In 55% of the aggravated durational departures, the court did not provide any information on the position of the prosecutor. There were no cases in which the court stated that the prosecutor objected to the aggravated durational departure. In 77% of mitigated durational departures, the court stated the prosecutor agreed to the departure, recommended the departure, or did not object to the departure. In 5% of these cases, the prosecutor objected. This slide displays both mitigated dispositional and mitigated durational departures by race, ethnicity, and gender. Recall the mitigated dispositional departure rate is 46%. The mitigated dispositional departure rate in blue is higher for women at 66% than men at 44%. The mitigated dispositional departure rate ranged from a low of 34 and 35% for the American Indian and Hispanic groups to a high of 50% for the Asian groups. Recall that the overall mitigated durational departure rate is 19%. The mitigated durational departure rate was higher for males than for females at 20% versus 15%. The mitigated durational departure rate for race and ethnicity varies from a low of 15% for the Hispanic category to a high of 32% for the Asian category. When we look at the racial and ethnic groups, we see that the white group had a higher mitigated dispositional departure rate than the total rate, but a lower durational departure rate. The Black and Asian groups had higher mitigated dispositional and durational departure rates than the total rate. And the American Indian Hispanic groups had lower mitigated dispositional and durational departure rates than the total rates. The mitigated and the next one we'll see by judicial district. And the mitigated dispositional departure rate by district ranged from a low of 33% in the 8th district, which is West Central Minnesota, to a high of 58% for the 2nd district. Downward durational departures among prison cases range from a low of 5% in the 8th to a high of 47% in the 2nd. Note that the observed variations may be partly explained by regional differences in case volume, charging and plea practices, as well as differences in the types of offenses sentenced and the criminal history scores of those individuals being sentenced. And that would conclude our presentation.
All right, any other questions from the commission? I guess we don't have any other questions. Do you have anything else, Nate, that you want to?
Not on that, Madam Chair.
All right, so this summary, which I'm hearing will change somewhat, will be included in the review of the draft report, or some of this information will be included in our draft report to the legislature. So we'll move on to that topic.
Thanks, Madam Chair. And yeah, it's my intent to kind of skip over that since we basically just did the data portion. So this is the draft of the 2023 report to the legislature. You are required to do a report to the legislature annually, and basically the three purposes, the required purposes of the report are set out at the introduction. You've got to identify and explain all sentencing guidelines modifications made during the preceding 12 months. And I really haven't done a history of the sentencing guidelines since 1980, but there were no changes. So this I don't know if this is the first year ever that the commission made no changes, but you know, I'm just leaving it at that. I'm not going to say because it was, you know, the legislature didn't get much done, or because the commission backed off on what it was going to do last January, but the upshot was there were no changes to the guidelines this year.
Before you go any further,
Yes.
Did you intend for that to be showing?
I did.
It's not showing to the.
Oh, it's not showing. Oh,
on the
thank you.
WebEx right now.
Thank you. Thank you very much. All right, so. Sorry about that.
There you go.
So this is the report to the legislature for those following along. The second is to identify, explain, and submit to the legislature any proposed modifications to take effect in 2023. We do have some of those pending the outcome of this public hearing. So the public hearing that we just had earlier today. So that's all subject to your vote in January, which will be basically the day before this is due. And then the third is to summarize and analyze reports received from county attorneys on criminal cases involving a firearm. That's not our data, that's the county attorney's data that's reported to us, and then we're required to report that. But these are all legislatively required. And then the commission generally does other things as well. Reports on a legislatively mandated review, recommends changes in criminal law, and highlights other topics, including sentencing trends and commission activities. We typically have reported on the Minnesota's imprisonment rate compared to other states. We were in a tie with New Jersey for the fourth lowest in 2020. And this is according to this is the imprisonment rate. Now I've heard references to incarceration rates, and I'm not sure where where data is coming from. This is Bureau of Justice Statistics publishes imprisonment rates annually. They're going to be publishing their 2021 report next week. So we should have updated data for you in January that will reflect how Minnesota compares to other states. Like I said, we were tied for fifth, so I wouldn't be surprised if we're fifth next time. You can kind of see the national curve versus the state curve. The state curve is the lower one. We've typically been at about half of the imprisonment rate, but at points we were lower than that of all states. But we'll see if that trend continues. Obviously, COVID affected everybody, but there was a decline before COVID. And we also have reported the probation rate, which we do have the fifth highest probation rate among all states. And that is current data. That's not going to change. 2020, we're not going to have 2021 data. So that's the introduction. Then we have the executive summary, which I'm going to skip over because I'm going to be going through the different parts. Other than here's the sentencing practices summary, which we talked about these things in our presentation. The first part of the commission's work kind of describes who's on the commission and what changes there have been to commission members. And then we go into the first topic was changing the calculation of the custody status point. This does assume that the commission is going to take the action that it proposed to take in November when it forwarded to a public hearing. Obviously, none of this is final because the commission hasn't taken final action on it. But we assume, as we always do, that the commission will take the final action in accordance with what it voted to do prior to the public hearing. I'm not going to go over the history of this. I think you're all pretty well familiar with the history of the half-point problem. This is basically an abbreviated version from the 2021 report. I'm sorry, the 2022 report, last year's report, which the legislature is welcome to refer to if they like. We talk a little bit about the roundtable led by Kevin Reitz and the proposals, and then we describe how this change solves the problem. So if there are, if particularly the proponents of this proposal feel like this doesn't accurately capture the reasoning behind the proposal, please feel free to send me any changes, and we'll be happy to incorporate those subject to final vote. But we'll talk about the commission's calendar later, but some of the problems with our current calendar structure is that most of the time our January meeting is literally the day before the report to the legislature is due. And 2023 is no exception to that. So we can't make a lot of changes based on meeting input in January. So if you have any changes, now would be a great time to get those. But I mean, I'm not saying we won't make changes that are requested to be made in January. Obviously, we have to do that. But it is much more of a burden to do that in the January meeting than it is to do it right now or sometime between now and January.
Madam Chair.
Commissioner Chanel?
Nate, can I just ask a question? And I'm going to go back to kind of where you started in terms of the introduction stuff. Mm-hmm. Just because I think there has been a lot of conversation about the question of, where we rank relative to imprisonment rates nationally. And I'm wondering, again, this goes to a context question around looking at imprisonment rates for Minnesota as listed here per 100,000. And if there would be any kind of value, contextual value in looking at crime rates, general crime rates per 100,000 population as reported by BJS. And I guess what it begins to do, if you look at national versus Minnesota, does it start to give some context for the extent to which, imprisonment rates and tie or correlate in any kind of similar kind of fashion. We may not have as much historic data here, but in any kind of fashion with imprisonment and crime compare. Does that make sense?
Yes, it does. I'm not an expert in this. I have seen cautions against comparing crime rates between different jurisdictions. I think the crime rates are reported by the FBI. I believe I saw a study done, I want to say it was by Pew Research. This was a few years ago now, after different states. So this was sort of the point at which the curve was starting to bend down, sometime in the teens. And it was basically looking at the impact on crime rates among jurisdictions that had reduced their imprisonment rates. And I think the point that they were attempting to make was that there was no increase in crime, that the jurisdictions that decreased their imprisonment rates did not experience an increase in crime, for example. I don't know how sophisticated that analysis would have to be meaningful. In other words, I don't know if we necessarily would have the resources to do that. We do mention crime rates a little bit later in the report, but we've never really tried to do any kind of a full-throated longitudinal analysis of crime rates and compare it to imprisonment rates and that kind of thing. It might be interesting. I think there's a little bit of an apples to apples. Got to make sure you're comparing the same thing across jurisdictions. But I think the FBI tries to do that with their offense categories.
Right. Madam Chair, I guess my thing was just, I didn't want to get so granular because I think it can be a bit, kind of weed and trying to sort out the differences. But if you look at generally across national crime rates, just that are national, and then compare that against state, a little bit like what we're doing here when we talk about imprisonment, generally, as you're taking a national on the one line, at least that's my understanding of it, versus where Minnesota lands. I just think it would be an interesting comparison. And again, I wouldn't suggest in any way that the two necessarily correlate or that it's scientific, but it just, we hear a lot about the issue or of Minnesota's relatively low imprisonment rates, and to what extent there is corollaries as it relates to crime rate. I think is a bona fide question because it does become a point of discussion regularly. So how do we begin to contextualize correlations between imprisonment rates, high or low, and crime rates in the broadest sense possible? That's what I'm trying to contextualize.
I think the reason I'm hemming and hawing is because at one point I was looking this up and on the FBI website, and it was like, looking for what's the safest city in America, or what's the most dangerous city in America, and basically what I got was a lot of hemming and hawing, and those aren't necessarily really valid comparisons to make. So that's maybe why I'm a little gun shy about this, but I mean, I'm sure the data are out there, and I'm sure we could find a way to easily, or not easily, but clearly present those data. So we'll definitely take a look at that.
I just raised it as a question more than anything.
Interesting.
Thank you.
Well, and I've always wondered, like, is there a correlation, and I'm sure it would be lagging, but is, because cases aren't sentenced immediately. The crime rate is, I think, when they're reported to police, and can include crimes that were never solved, much less charged, much less convicted, much less sentenced. So there's definitely a delay there. But I've always thought it would be interesting to compare our sentencing practices to the amount of crime that was committed in Minnesota during that time. You know, if that was a high crime era or a low crime era.
Well, I just want to say that I share some of your concerns with how to present the data, just because I agree that there are problems with doing a direct comparison. Maybe it's possible to have a different chart that shows national crime rates and state crime rates or something like that, that's not directly comparing imprisonment rates. I don't think you have time right now to figure out the right way to do that. But, you know, maybe there's something that you can look.
Yeah, and I will say, while we're talking about that, index crimes are really a select group of a very small subset of very
Right.
serious crimes that I think everybody would say, oh yeah, that's a serious crime. You know, I think it's like armed robbery and murder and sex offenses, and that's probably what I would use. But you know, if there's a whole bunch of you know, thefts that's going on, they're not going to be captured in that,
Right.
even though people might not feel safe if you know somebody's you know, you can't leave anything out on your lawn or it's going to get taken. You know, I don't. So that wouldn't be included in the index crime rate, but it might affect the sentencing rate.
Let me just make one more comment, and then Commissioner Knudsen. The other thing I would say, if we're talking context, then I think that what this chart does not show is the size of our correctional population, because if you include probation, then you know the other number that the BJS tracks is the correctional control, and we have one of the larger correctional control systems when you have prison and probation together.
Right. And
So
we
you
do-
have that number there, but we don't
Right.
see that.
Right, we have it in a
scale.
paragraph here, but we don't have it over time, and we don't have it graphed.
Right, exactly. Commissioner Knudsen.
Well, I think these are the real questions in the analysis, and that would be meaningful and helpful for our work here. But boy, if I had that while I'm looking at sentencing somebody and what's going to make a difference in this person's life, and we know from statistics or data that kind of generally go this way, that way. So when you get around to Commissioner Chanel's research and get to that, so add in this last part where we're the fifth highest amongst all states on probationers per capita.
Right.
And then what would be interesting is to have, but even if, so we got all this information, but what does it really tell us? You know, that's what's hard to get to. What does it really tell us? So are there any states where those rankings have significantly changed? So they were one of the higher incarceration rates, and then they dropped. Or they were one of the lowest states of offenders on probation, but then they moved up significantly. And then what was the corresponding change or delta on their crime rates? Can you get that done by?
Well, no, but I mean, I know that's what Pew was trying to look at with some of those reforms that were happening in the teens. They were making the pitch that these states safely reduced their imprisonment rate. Like it reduced it, and that's not my analysis or my data. And I'm very confident that that's way too sophisticated for us to be able to do with the resources we have, especially by the next meeting. But yeah, it's I mean, it is an interesting question, for sure. I mean, the point of this in here, I think, is to support the proposition that, or at least support the inference that in the 1980s, the United States, and I should say this blue line is not the US rate per se, it's the all states rate. So federal is not part of this picture at all. This is just 50 states versus one state, essentially. But in the 1980s, imprisonment rates took off, and they took off across the nation. And the inference is that because Minnesota implemented a sentencing guideline structure beginning in 1980, that it did not partake in this really rapid rise in imprisonment rate that we saw across the nation. And yet there was no, I guess, perception, and maybe that's something that we should be quantifying, as Commissioner Schnell said, no perception that we became like a lawless state, and yet we did not partake in that enormous rise. And I would say there's a question that maybe we're not partaking in the fall that other states are having now for the same reason, because we have this guideline structure that's kind of locking practices in place. But it's possible that the sentencing guidelines are kind of a moderating influence on dramatic changes in imprisonment rates over time. And I think that's why this is in the introduction of this report. All right. So I think I was talking about the rationale for the changes to the custody status point and inviting any comments on that, if that's desired. The second part of, and this is under the subheading of the Commission's work in 2022, the second part of this is reviewing how the sentencing guidelines address sex trafficking. So we recap the legislative mandate, which we got in 2021, but we didn't have time in 2021 to do anything about it. So all the work on this review has happened in 2022. A very brief summary of the sex trafficking review. We can certainly expand on that if they think it's important, if you think it's important. And then we have a section here on unfinished work, and that's talking about prostitution. So prostitution was not literally part of the sex trafficking review, but the proponents, the Central Minnesota Human Trafficking Task Force, asked us to look at prostitution offenses. And the commission did look at that, but really didn't have time in 2022 to take final action on that. So this is one of the points where we're making a promise to continue to study it in 2023. So if you don't like that promise, we can take that out. There's a few other places in there where we're saying that we intend to continue looking at it in 2023. And then we have the proposed changes, which was also part of this public hearing. It wasn't just custody status point, but the changes to rank aggravated sex trafficking rather than make it a modifier, and to add select sex trafficking offenses to the severe violent offense list. So those are described in detail. And then we have this section on legislative recommendations arising from the sex trafficking review that aren't necessarily all about sex trafficking itself, but these are legislative recommendations that the commission made to basically fix, I think you could say, errors in the statute that we found during this review. Then we have other work in 2022. So this is the third and final part of the commission's work in 2022. The first part is the continuation of the neutrality review, which is where I kind of went back and looked at Professor Hugin's and Hannah Schwennemann's slides and drew some of the findings, which is where I got this adjusting for all these factors. They reported that non-white Minnesotans were less likely to receive mitigated disposition departures and more likely to go to prison, but also more likely to receive mitigated durational departures than white Minnesotans. So that was kind of adjusting for a number of different factors. This is another point where I'm saying the commission intends to continue. So if this isn't your intent, we can take that out, but the commission intends to continue its neutrality review in 2023. Proposed technical modifications to the sentencing guidelines, and again, I don't have any editorial comment here, but I just say the commission reports no changes to the Minnesota sentencing guidelines and commentary in 2022. That's because that's a required part of this report, and there are no changes to report. Then we talk about staff's work, just pretty similar to what we
Nate,
do.
before you get
Yes,
too
ma'am.
far away from the commission reports, no changes, I wonder if we should add 2 sentences to that. Because I mean, normally that would be our ranking decisions, but
Right.
there were no new or amended crimes passed during that legislative session, so we
Yeah.
didn't have any of that work to do.
Yeah.
I wonder if a sentence or 2 there would just clarify why there was nothing to
Yeah, I
report.
mean, from my perspective, there were 2 reasons why there were no changes to the sentencing guidelines and commentary in 2022. One is the legislature didn't really make any changes to the criminal code I mean, the only change that they made that the commission might want to take action on had a very delayed effective date, so it really didn't need to take effect in 2022. So, yeah, it's and then the other thing is the commission had spent quite a bit of time in 2021 looking at making changes to the custody status point calculation, and then backed off on making those changes in January. So the 2 sources of changes typically are commission initiatives and response to legislative action, and both of those ended up being kind of a goose egg in 2022. So that's why there's nothing there. But I can certainly write up a couple of sentences explaining those 2 factors if you like.
It might be helpful.
Okay. All right. And then let's see. Staff's work, we're busy. We do have links to demographic impact statements that we did. Legislature's often interested in those. And then this is the 2021 sentencing practices data summary, which hopefully we went over in our previous discussion. I would say one thing that didn't get brought up. There was a period of a few years that so the big 3 categories are person, property, and drugs, right? And there were a few years there where drugs actually took the #1 spot, which we had never seen before. That's kind of gone back to person again. So that has receded. And then the final real section of the report is the firearms report. And I don't know if Executive Director, retired Judge Robert Small is still on the call, but just in case somebody happens to be listening, I'd like to just list off the counties. So all 87 county attorneys are supposed to report to us their 60911 cases. 60911 is not a number, it's a statutory citation. It's the mandatory minimum statutory citation. I'd like to just read off, if I can find it here quickly. Oh, apparently Bob already has it, so he's on it. Robert Small has done a very good job of getting county attorneys in line. We do have a few counties that don't have it. I was going to read those off, but it looks like Judge Small is ahead of me. So all this data is going to change. We have not attempted to update all this data for 2021, fiscal year 2021. So, I'm sorry, this would be fiscal year 2022. So all these data will be new by the time you get it in January. So I apologize for that. This is last year's data, but this is how we present it. This kind of shows the flow, and this has been referenced before, of how many people are or are not getting the mandatory minimum. And I guess from my perspective, it really depends on where on this chart you decide to start looking. I mean, if you look at all cases allegedly involving a firearm, well, some of those may not turn out to be anything. They may not really be cases. And then how many of those were charged? and ended up getting convicted of a non-designated offense. I think here when you look at the brown or maroon or whatever that color is, convicted of a designated offense, you're getting closer to what I think is important. But 52 of these cases from last year's data, the firearm was not established on the record. It has to be established on the record for the mandatory minimum to apply. So these 534 cases are really the cases where 60911 applies. And of those 297 cases, the mandatory minimum was imposed and executed. 237 of them, county attorneys report that it was waived. About a 50-50 split last year by either the waiver was by the prosecutor or the waiver was by the court. And the statute permits both of those sources of waiver. Now, all this data is from the county attorneys. It's not our data. We do not confirm or deny this data. We do have a footnote, and this footnote is footnote 40, and we actually did update the footnote 40. Footnote 40 is our data. It's a little bit apples to oranges because they're looking at fiscal year data of cases, and we're looking at calendar year data of sentences. And but this shows our data on 60911 cases that we're aware of, which may not be all the cases that the county attorneys are aware of, but I'll just say our data and the county attorney's data do not always match up. And that's in footnote 40. And then we have charts that show it. Then we have the appendices. Appendix 1 is the actual text of the proposed guidelines modifications. And then Appendix 2 is the legislative recommendations. There, which would the actual text of the legislative recommendations. I should say on the legislative recommendations, I also threw a footnote down that said that the legislative recommendation that you made a couple of years ago to establish a minimum term of imprisonment for murder of an unborn child in the first degree still has not been addressed by the legislature. So, to me, it's not unforeseeable at all that somebody could be convicted of. So far, it's always happened with the murder of the mother as well. So the mother first-degree murder was always the controlling sentence. But it's very foreseeable in my mind that it could just be the unborn child who's killed, and then there's really a mystery as far as what is the minimum term of imprisonment. The only thing we know is that it's not life without the possibility of release, because the Supreme Court has told us that. But we don't know what it is. We just know what it's not. So really, it's something that the legislature needs to. It's just a void in the statute that the legislature needs to address. So I did take the liberty, since you've never repealed that recommendation, of just dropping a footnote to say this is still an outstanding recommendation, and I will probably mention that to the legislature when I'm testifying in front of them next year. And then Appendix 3 is the sentencing guidelines grids, and Appendix 4 is the map. Any other questions or recommendations or changes that you'd like me to make on this?
Comments or questions from commission members, or anything that appears to be missing or you want to see differently? Guess not.
All right, and I will just say for the benefit of the public listening, this is a draft document. This has just been prepared by the staff of the Sentencing Guidelines Commission. There's nothing final about this document. The document that we will publish on, I think the 15th is a weekend or holiday, so it's whatever that Friday is before the 15th. That will be the official document that the commission will have voted on at its January meeting.
And so in January, just to clarify, Nate, the things that we can expect to see updated are if there's any changes to the annual data, that'll be updated. Hope you expect to have the completed firearms report updated by that point. And then the pieces that will remain, the pieces that will remain in draft are the pieces we had the public hearing on today because we have not yet taken final action.
Yes, so we will have the imprisonment rates because the BJS will be publishing that
Oh,
next
right.
week. I've been promised, just in time for Christmas. And they'll also have, we'll have some more information, and I can't exactly tell you what it is. We're gonna have a little more detail about the 5-year probation cap and some of the statistics on that. But otherwise, I don't see any changes being made to that whole section. And then a lot of it is going to be contingent on your vote. So we'll, I mean, obviously you'll set the agenda, Madam Chair, but my recommendation will be to take the vote first, and then move to the report to the legislature.
All right. Okay, well, if that's it for that section, then we'll move on to item 6, which is the agency rulemaking docket.
All right. Thank you, Madam Chair. So this was, I think this agenda item flows from, I think, 2 things. One is Commissioner Larkin, I think was it last year or the year before, made a comment about how, you know, if I recall, Commissioner Larkin, it was something like it'd be nice to take action after the public hearing, and then have the January meeting to finalize the report to the legislature, knowing what. So there weren't any, you know, big policy questions out in the open. And I will say, in 2022 and 2021 at our January meetings, the commission did not go in the direction that we thought they were going to go based on what was sent to the public hearing. So staff certainly concurs with that sentiment, if that was Commissioner Larkin's sentiment. The other thing is, it's just a little bit tough to have 2 public hearings during the calendar year. One is like a for sure public hearing in July, and then the other is this December public hearing, which we're not really sure if it's going to happen or not, but it happens almost every year. I think it's been almost every year that I've been director, we've had a public hearing in December. So it's the thought is that we could change our calendar to streamline it a bit, but in order to do that, we'd need to change our meeting rules. So what are our meeting rules? You probably didn't know we had meeting rules, but we do. There's this thing called Chapter 3000 in the Minnesota Administrative Code that has meeting rules, and those are rules that the legislature authorized and required the commission to make back in the 80s. So the commission is not subject to the Administrative Procedure Act when it comes to promulgating the sentencing guidelines, but it is subject to the Administrative Procedure Act when it comes to promulgating the rules for promulgating the guidelines. So under the Administrative Procedure Act, the commission made these rules, and these rules have this public hearing process that basically takes a 7-week bite out of our calendar. And we saw that ran into a problem in 2021 when the legislature did not take action during its regular session. The legislature instead passed a bunch of crime bills, very significant crime bills, but it passed them on June 30th of 2021, which didn't leave enough time for the commission to take action, given this 7-week chunk of time that's required under the current rules in order to get those changes in effect by August 1st. It just wasn't mathematically possible. So the tail kind of wagged the dog that year because of this 7-week requirement that we have in these rules from the mid-'80s, we had to ask the legislature to postpone the date of the effective date for all these crimes to September 15th. And the legislature did, which was great because that meant that the sentencing guidelines and the changes to the laws were all synced up and everything took effect on September 15th. But really, the idea here of this paper is, do we really need to take that 7-week chunk out of the summer? Couldn't we just kind of keep the meetings moving along a little more quickly by having a streamlined public notice and comment process without having this formal publish the notice in the state register, which I'm not sure how many people subscribe to the state register, to be honest. So publish that in the state register and have this delay period where we have to wait 30 days and then have a public hearing and then have a 5-day period after that and then have another meeting. The thought is we could just have in between meetings, just say, hey, the commission's considering making these changes to the sentencing guidelines. If you have any input, send it in writing before the meeting. You get, say, 2 weeks to do that, or show up at the meeting and make some statements, and then the commission will vote, and you'll be done. And typically, these are not controversial proposals. These are, the legislature has created a new crime. How do you rank that new crime? Or the legislature has changed the elements of a crime. Does that make it more or less serious? Do you need to change the rankings on those crimes? And a lot of the times, we don't get any input from the public on those at all. The public seems satisfied with the decisions that the commission makes. So what I'm thinking is the commission could, through a rulemaking process, change those mid-'80s rules that it made and streamline it. And then at the end of this paper that I've presented, I've given you sort of an idea of what a calendar could look like, where we just continue to have meetings all the way through the year, every month, until late October. And then late October, that's when you'd have the public hearing for commission initiatives. And commission initiatives are where we've historically gotten the feedback from the public. So there we could have a public hearing every year, 1 week after Thanksgiving, which would be, I think, far enough before the holidays. It wouldn't conflict with too many people's schedules. And then 1 or 2 weeks after that, depending on when the judicial conference is that year, the commission would meet and take action on the public hearing. So that would be done then in December. And then we'd have a hearing in January, a meeting in January to actually finalize the report to the legislature. And what we're asking for in this calendar that we've drafted is that not be the day before it's due, that it be a little bit before that. So that could be as early as January 4th, unfortunately. That is a little bit close to the new year, but if it were a week after that, it'd be the day before it's due. So that's kind of a roadmap going forward. We're certainly not asking for action on that or approval on that at this time. We're just introducing this at this point. But there is this thing called a rulemaking docket. And all agencies are supposed to have a rulemaking docket, all agencies that make rules. And this is the area in which the sentencing guidelines makes rules under the Administrative Procedure Act is Chapter 3000. So if you're thinking about changing Chapter 3000, it's appropriate to have a rulemaking docket where you're sort of putting the public on notice. And other agencies have this, like on their websites, where they'll have a rulemaking docket. Here are the rules that we're changing. Here are the rules that we're thinking about changing. And you've got to say what the changes might be about and what the status of those changes are. Then you're also supposed to report that rulemaking docket to the legislature, to the committee that has jurisdiction over the agency, which in our case is always the crime committees of the House and Senate. You're supposed to report those by January 15th. So my thought is that if you're interested in exploring this in 2023, again, this is another thing to load into the backpack for 2023, but if you're interested in exploring this for 2023, it would make sense, it seems to me, to have a rulemaking docket. And I've got language in your materials here on what the rulemaking docket would look like. And this doesn't commit you to make any changes at this time, but it does put the legislature on notice. And I'm gonna scroll down here. I realize I'm not sharing it yet. So I'm showing on the screen what the language would look like. So what I'm proposing is to ask you to vote on, if you like this, putting this in the report to the legislature, agency rulemaking docket, basically putting the legislature on notice that the commission may be looking at modifying the sentencing guidelines to streamline the public and notice comment requirements for a modification that relates to a crime created or amended by the legislature in a preceding session, or a modification that the legislature has mandated or authorized. So that's really the limited scope. I'm not suggesting making any changes to the public hearing process for commission initiatives, but if it's in response to something the legislature did in the preceding session, I'm suggesting that that could be streamlined, and it would really, I think, make your whole calendar flow better. So that's my pitch, Madam Chair.
Commissioner Knutson.
I would just suggest that you add into this language what you just said, but this does not apply to any commission policy changes
Right.
or something like that. That we're not looking to modify those procedures.
That sounds like a good addition. Others, comments, suggestions?
Well, and Madam Chair, Judge Knutson, for full disclosure, I think there are some modernizing things we could do to the rule that would generally apply. Like right now, we're supposed to have a U.S. mail mailing list. We don't use a U.S. mail mailing list. Everybody gets notified electronically now. So I think we'd like to just kind of update that, but that's in the language of eliminating the U.S. mail mailing list.
Yeah, I was gonna, what I was going to, it didn't feel like you had, in the paper, you had emphasized the difference in the types of proposals that could potentially go to a notice and comment period versus the full public hearing. And you hadn't emphasized that. So I think we just talked about that, but
Yeah.
you're saying, I mean, every year the legislature amends or creates new crimes and we rank them. And so that would be one of the things that we could streamline to a notice and comment period potentially. And sometimes they tell us to take specific action to change the guidelines.
Right.
And so that might be a change that we could do through notice and comment rather than a full public hearing. But like everything we had a public hearing on today would still be in a public hearing process because those were significant changes to the guidelines that the legislature has to see before they go into effect.
Right.
So that's the difference here. I think that's a really interesting idea. And any agency that hasn't updated their rules since 1985 probably should. Any other comments? Commissioner Schnell.
I just want, the only thing is, do you think because the limit, it's pretty limited, that just because the complicated nature of some of this, and maybe the sentencing guidelines, staff is really in a great place to do that, but it's a fair amount of work. Rulemaking, just the process itself, all of that stuff. Do you have any concerns about that relative to demand on staff?
Madam Chair, Commissioner Schnell, I mean, I've never done rulemaking. I know that there are some really good sources from the revisor's office and from an interagency rulemaking committee, and they both have pretty thorough soup to nuts manuals on how to do it. Almost, I mean, the interagency is almost like a cookbook on here's the process that you go through. I mean, I think it'd be good to do, so I'm willing to do the work. So I think we could do it, but I'm also an optimist. I mean, but there's no timeline on this either. I mean, it's not like we have to do it by a certain date. I think it'd be nice to have it in place by calendar year 2024, sort of to, because otherwise it's going to be the day before the report to the legislature is due again, or maybe even by Thanksgiving, so that the public hearing would be the Thursday after Thanksgiving, and then the commission could. Well, I guess you could do that anyway, honestly, but yeah, I appreciate your concerns, and I may be, this may be a case of fools rushing in, but.
No, I don't think that at all. if anybody could do it, I think you can. It is just my limited experience in the last couple of years. It is a grinder, and some of it, scope certainly may be a part of that, but yeah, it's good, and I think it is the right thing to do. Absolutely, the right thing to do. So I'm with you on that.
So, Madam Chair, I don't know if you want to take a vote. I mean, I'm hearing generally positive things. The other alternative is I could just put it in the report to the legislature draft that, and then you could just take it up then. And so I don't think it's necessarily required that you take a vote at this time, but if there's no objection to me just kind of trying it out and seeing what it looks like to put a rulemaking docket in the report to the legislature, we could just postpone it till that time. If you take action today, then we would actually put a rulemaking docket on our website, so the public was generally on notice.
What do commission members want to do? Commissioner Schnell?
Do you have a preference, just from a staff standpoint?
I think it'd be nice to have a rulemaking docket on, it was a little bit of a pucker effect when I looked at the statute and it says every agency will have a rulemaking docket. And I'm like, oh, shoot, we don't have one. So, I mean, it'd be nice to come into compliance this year so that we could just say we have one come next year, but it could go either way, whatever the commission wills.
I would move to adopt this rulemaking docket and ask staff to prepare this as part of the report.
And is that with Commissioner Knutsen's suggested language change?
Absolutely, conditioned upon that, in fact.
Okay, so Commissioner Schnell. Commissioner Schnell makes the motion and Commissioner Middlebrook seconds. Do we have any discussion on the motion? Hearing none, I'll ask you to take the roll.
To the Schnell motion for the commission to adopt the rulemaking docket as presented by staff and as with suggested changes by Commissioner Knutsen. Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim? Ibrahim absent. Knutsen?
Yes.
Knutsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell? Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
All right, and with that, the motion is approved unanimously. Thank you. All right. Number 7 is modification to comment 3C.01.
All right, so I kind of alluded to this briefly when I was talking about things that the legislature did do in 2022, and this was one of the things they did do. They made changes to, let's see, let me just pull it up here, to jail credit rule. This is not something that we got to you in time for the public hearing, but it is, it's not a change to the sentencing guidelines that we're suggesting. It's a change to comment 3C01 to add a reference to section 611.51. Which is a new statute that establishes a jail credit rule, and 3C01 is basically cross-referencing jail credit rules in statute. So we think it's helpful to practitioners to have cross-references in commentary, so that they know if they're looking at a rule that's maybe not always in effect, it's good to know that. And so we're recommending adding 611.51. And then there's also just a typo on a reference to Rule of Criminal Procedure 2703. So that's what we're suggesting, and then that would also go in the report to the legislature as a change effective August 1st of 2023. And if I recall correctly, the effective date is, it's July 1st of 2023. So it would almost line up effective date-wise. And it's just the commentary anyway, so it's not a huge deal if it's a month late.
Okay, so you're asking for approval to amend the comments so that we have the correct cross-references to this new jail credit statute, and we correct the technical error in the language that was there. I would entertain a motion to approve the change. Commissioner Estrada moves. Do we have a second? Commissioner Middlebrook? Oh, Commissioner Larkin seconds. Any discussion? Hearing none, if you could read the roll.
To the Estrada motion to modify comment 3C01 as recommended by staff effective August 1st, 2023. Estrada?
Yes.
Estrada, yes. Hansi? Hansi absent. Ibrahim? Ibrahim absent. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore? Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
All right, and with that, the motion is approved unanimously, which takes us to item 8, the Executive Director's Report.
Merry Christmas, Madam Chair.
You got nothing for us?
Nothing else.
That's awesome. Okay, and then last item is public input. So let's open it up for any additional public input. So we have one person in person, and then you have to say the procedure for online.
Thanks. Yeah, so I would ask staff members who are listening in online, please raise your hand to confirm that you can raise your hand. All other members of the public listening in, I would ask you to raise your hand if you would like to make a comment. I see at least one hand has been raised so far. I've got Matt Majowski. Let's see. Oh, actually, I don't see any staff who aren't.
There was one.
Well, Ann's there, but anyway, it looks like Matt's got it. Oh, I see Shauna's raising her hand. Okay, so the hand working seems to be working. So did you say there was somebody in
Yes,
the room?
Mr. Zimmer would like to make a comment, so I'll ask you to come forward and make your comment, and then we'll move to Matt Majowski, and then if anyone else is interested who's online, please make sure you raise your hand before we get there.
Madam Chair and Commissioners, a comment was made, and I'd like to clarify. The director, in some of the earlier comments, was talking about departures by race, and that some presenters that had come before the commission earlier last year had presented facts that the people, white defendants or white people sentenced receive a bigger departure or more frequent departure. And that seems to differ from the data that the commission has and publishes. And so we all just saw the 21 data, and I brought with me the 2020 data. And overall, and all I have is a comparison between white and African American. But in 2020, there whites received a 45%, whites received a downward dispositional departure 45% of the time compared to 41% for black. That changed now in today's data for the 21 report to 48 versus 47, so very similar. And then for the durational departure, whites receive a downward durational departure 16% of the time, blacks 30% of the time. I did a 5-year average and it remained fairly consistent. Whites at 17.6% and African Americans at 30.5%. And then finally, another data point that the commission has is the presumptive prison commit rate by race. And in 2020, the white presumptive commitment rate was 31.9%, and they were actually committed 20.1%, a difference of 11.8%, whereas African Americans received a presumptive commitment 48% of the time, and actually were sent to prison 27.7% of the time. That equates to a difference of 17.1%. So I just wanted to, I guess, make clear that the data is differing from what your presenters had suggested. And I'd be open to hearing from you, or we can talk offline. But I wanted to make that point. I also wanted to respond to Commissioner Schnell's question about, I think it's a great question, and I think this commission would benefit from having data that shows where Minnesota stands in crime rate, and maybe even more specifically, Part 1 crime rate, the crimes more likely to result in a prison commit, and then compare that to where we stand in terms of our incarceration rate. And I'll just tell you, I've done the data, and it's in 2020, for the first time ever, we exceeded the national average for Part 1 crimes. So I forget exactly where we rank, but it's at least, in the upper half. But like we saw today, we are 4th or 5th in the nation for our low incarceration rate, imprisonment rate. And somebody mentioned that the correctional, I forget what the term was, but the correctional oversight.
Correctional control.
Control rate, okay. That we rank near the top in that. And I would say that the fact that our Part 1 crime rate is somewhere in the middle equally argues that maybe that's too high and the imprisonment rate is too low, and somewhere there should be a happy medium. I just wanted to make that point, and I would offer assistance in gathering data, certainly not, the commission and the staff can make the final determination on the importance of it or how it correlates, but I would certainly be happy to help gather data.
I'll just, I'll take one step to clarify the difference you might see in those, the departure rates versus the data that Professor Eugen and Hannah Schwindeman presented to us. Their study was controlling for all factors. So they were controlling for the seriousness of the offense, the person's criminal history score, and other factors. And when you control for all of that, there's still a departure rate, a dispositional departure rate that is explained by race rather than those other factors that matter. And so that's the difference. Descriptive statistics don't take into account all of those factors at once, whereas their study was taking into account all of those factors at once, and that's the difference in the results that you might see.
Okay. Thank you.
Thank you. Thanks for coming forward. All right, it looks like Matt Majowski has your hand up, so I would invite you to unmute and go ahead and make your statement today.
And I think I've got to
Oh,
take care
maybe,
of that, so.
maybe we have to unmute for you. Hang on.
All right.
Whoops.
Oh, okay, Mr. Majowski, you can go ahead.
Thank you, Madam Commissioner, Madam Chairman, and Commissioners. Appreciate all the work that you do. Matt Majowski, Dakota County Probation Officer. Today, I've been watching and listening to the public hearing and your meeting from home. And during one of the times when Nate was speaking, my wife walked by the office where I'm at, and she asked, "Who is that?" And I I told her, and she said, "Oh, he sounds like Burl Ives." So I thought it would be appropriate to share that during this time of year when we hear Burl Ives, on the radio through streaming services. But wish you all a very happy holidays and a wonderful new year. Thank you.
Thank you.
I will be taking requests after the meeting.
That's great. Is there anyone else who would like to make a comment today? I don't
see anybody, Madam
I
Chair.
don't see anybody else. All right. So I think that brings us to the end of our agenda. I want to echo what Mr. Majowski just said. Happy holidays to everyone. Have a wonderful last couple of weeks of the year. And we will see you all back here on January 12th in 2023. This meeting is adjourned.